Hello friends, today I will dictate a legal passage, exercise number 4, with a speed of 120 WPM. I will start my dictation after 5 seconds. December 2022 to February 2023, the appellants apprehended that their engagement was likely to be discontinued and that the said extension would be the final one. In this backdrop, the appellant submitted representations to the respondents requesting regularization of their long years of dedicated service and invoking the obligation of the state to act as a model employer. Aggrieved by the persistent inaction on the part of the respondents, the appellants approached the High Court by filing writ petitions seeking inter alia a writ of mandamus directing the respondent state to regularize the and absorb them against the vacant sanction post of junior engineers within bracket agriculture, and also seeking a declaration that office order dated 28 February 2023, whereby stipulations were introduced declining further extension of their engagement was illegal, arbitrary, and unsustainable in law. The learned single judge, by common judgment dated 14th March 2024, dismissed the writ petitions, holding that the appellants possessed no legal right to seek renewal or extension of their contractual engagement, and that no corresponding obligation was cast upon the respondent state to renew or extend such contractual appointments. Aggrieved by the judgment of the learned single judge, the appellants both Bholanath preferred an intra-court appeal. The division bench, by judgment dated 17 September 2024, dismissed the appeal, holding that the appellant's engagement being purely contractual in nature, no interference with the decision of the learned single judge was warranted, and accordingly affirmed the same. Thereafter, the remaining appellants also preferred intra-court appeals before the High Court, which came to be dismissed by separate judgments dated 15th October 2024 and 22nd October 2024 respectively. Following and relying upon the decisions rendered by the division bench in the intra-court appeal preferred by appellant Bholanath, aggrieved thereby, the appellants have preferred the present appeals before this court, assailing their respective impugned judgment and orders passed by the High Court. Submissions on behalf of the appellants: Sri K. Parameswara, learned senior counsel appearing for the appellants, strenuously assailed the current judgments of the High Court, contending inter alia as follows: that the appellants were appointed against and sanctioned post pursuant to a duly issued advertisement and after undergoing the prescribed selection process, including roster clearance. Upon joining service, the appellants were subjected to transfers, postings, and other service incidents ordinarily applicable to regular employees. The appellants have rendered continuous service without any break, and there is no adverse material on record against them. Their performance has consistently been found satisfactory, as is evident from repeated recommendations for extension and the uninterrupted renewals granted to them over the years, that the appellants have rendered service for a period exceeding a decade and are entitled to consideration for regularization in the light of the decision of the High Court in State of Karnataka versus Uma Devi. Denial of such consideration while continuing to take advantage of their unequal bargaining position is contended to be contrary to the principles of equity and fairness and violative of the constitutional mandate to ensure dignity in public employment. that the stipulation contained in the appellant's appointment letters bearing any claim for regularization or permanent absorption is contrary to public policy and hit by Section 23 of the Indian Contract Act 1872. It is contended that at the time of initial appointment, the appellants were unemployed job seekers and therefore did not possess any real or equal bargaining power vis-a-vis the respondent state, that the appellants were appointed against sanctioned and vacant posts and having worked on such posts for a period of nearly 10 years are fit to be considered for regularization in accordance with the existing policy of the respondent state, that the refusal of the respondent state to regularize the appellants is violative of their fundamental rights under Articles 14 and 16 of the Constitution of India. It is contended that although the appellants have been treated at par with regular employees in matters relating to service conditions, including postings, transfers, and increments, they have been denied the benefit of regularization. It is further urged that similarly stipulated persons have been extended favorable treatment while the appellants have been singled out without any rational or justifiable basis, that the appellants have crossed the age of eligibility for alternative public employment, and that discontinuation of their service after years of dedicated public service would leave them and their dependents in a precarious financial condition, contrary to the obligation of the state as a model employer to ensure fairness, dignity, and welfare of its employees, that the appellant's long and uninterrupted service has given rise to a legitimate expectation of consideration for regularization. It is contended that having diligently served for over a decade pursuant to a due process of selection, the appellants justifiably believed that their service would be regularized and that discontinuation at this stage would result in grave hardship. On the aforesaid grounds, the learned senior counsel urged this court to set aside the impugned judgments passed by the High Court, allow the present appeals, and issue appropriate directions to the respondent state for regularization of the services of the appellants. Stop.